Hey, Angela Langlotz here, trademark and business law attorney, and I want to share with you a cautionary tale. Today's episode is called What Happens If You Lie on Your Trademark Application. So here's what happened. I love these stories because they're great teaching opportunities. So it never pays to lie, especially on your trademark application. A client came to me, actually a potential client. I didn't end up taking him as a client because I couldn't help him because he had so thoroughly messed up everything that there was no way I could help him. Anyway, he came to me originally asking if he could stop an infringer, someone who was infringing his trademark. It turns out he had gotten a trademark registration, and I'm not telling anything I oughtn't here because I'm not telling you who it is or who it was or anything. So just that I never tell my clients secrets, of course. Anyway, he had gotten a registration for a term for podcasts. And as it turned out, there was somebody else that he discovered that was using that term for podcasts as well, and he wanted to make her stop. And so he asked me if I would write him a cease and desist letter. And as I always do, I dig a little bit deeper because I want to make sure that I understand exactly the situation before I go in with guns blazing. So I asked him, I said, when did you first start using this trademark? And he said, well, I have a registration and, it's registration, blah, blah, blah. And I went in and I looked at it and I said, well, that's great. But when did you first start using this trademark on podcasts? Because I want to make sure before I go in with guns blazing, like I said, that my client is actually the superior rights holder. And if someone else has used that mark on podcasts before my client started using it, even though that person doesn't have a registration, they still may have superior common law rights. So I really want to ascertain before I send a cease and desist letter who has the superior rights, because I don't want to write a letter and then find out, whoa, my client doesn't have superior rights. So I ask him, when did you start using it on podcasts? And he says, well, we actually haven't started using it on podcasts yet. And I said, well, hold on a second. You have a registration for podcasts, and the registration says that you have been using it since this date, at least as early as this date. That's what the registration says. He says, yeah, I know, but we actually haven't started using it yet. And I was trying to wrap my head around this. So just as an aside, you have to show use of the mark on goods and services in interstate commerce before you'll actually get a registration. Now, when you submit your trademark application based on use, you are required to submit what's called a specimen. The specimen is what shows the trademark examiner that you're actually using the mark on goods, right? The thing, though, is that you only have to submit one specimen per class. And in this case, podcasts are in class 009. The client had some other goods in class 009 that this registration was for. And so when he submitted the specimen, the proof of use, for the other goods in class 009, that satisfied the requirement of a specimen for all the goods in class 009. However, you do have to swear under penalty of perjury that you are using the mark on all the goods in class 009 that you're actually claiming in the trademark application, even though you don't have to submit a specimen for each good, for each type of goods in that class. So he submitted a specimen for the other goods in class 009, and he was able to get a registration for podcasts that were also in class 009 without submitting a specimen for podcasts because he already had a specimen submitted for the class 009 goods, right? So he's got this registration for podcasts and he's never used it on podcasts. He lied on his trademark application. Now, what are the consequences practically for that? What that means is that if you send me, if I'm using it on podcasts and you have a registration It means a couple things. You're going to send me a cease and desist letter, and I'm going to go look at your application or your trademark registration, and I'm going to say, what's the date of first use that you're claiming? I want to make sure that you're claiming a first use before me. And I'm going to ask you, if this goes to litigation, I'm going to ask you to submit proof of when you started using it. You're claiming use as of January 1, 2018. Prove it. I'm going to go look at the Wayback Machine. I'm going to go get other proof as well. I want to see your podcast episodes uploaded as of certain dates with the mark on it. This is all going to come out in litigation. So I told my client, do not send them a cease and desist letter, because the first thing that they're going to do is they're going to find out about the fraud, okay? And when you commit fraud on your trademark application, that is grounds for cancellation of the entire registration, not just the goods that you lied about, the whole thing, okay? Because you are swearing under penalty of perjury that the mark is actually in use as of the date claimed in your trademark application. And if you lie, that is grounds for cancellation. And it is grounds for cancellation even after the 5-year mark, after which most grounds for cancellation are not valid, okay? So, moral of the story, do not lie on your trademark application. In the event of future litigation, it will be discovered. You cannot hide it. Any attorney worth their salt is going to discover the fraud, and they are going to petition to have your mark canceled because of fraud. You can find me online at TrademarkDoctor.net. You can find me on Facebook at facebook.com/TrademarkDoctor. If you would like to be notified every time I go live in the future, please like my Trademark Doctor page. And if you have questions about trademark law, please comment on this video and I will answer your question in a future live. I'll see you tomorrow.